But it wouldn't matter.
damages.
But it wouldn't matter. That's what I'm getting at. It doesn't matter. She could have destroyed the whole thing. But regardless, under the provisions of this conditional order dismissal, that security deposit had to come back, which is not what the statute envisioned.
What looks like a simple security deposit dispute is about to turn into something much bigger. The tenant says she followed the move-out order and deserved her money back on time. But the real issue is whether this dismissal agreement changed the normal legal rules. And if it did, can the tenant still demand the statute's extra penalty? That's where this hearing gets explosive.
The court does call the case of Clara Gahan versus Holly Ellison.
Good afternoon, Your Honor. This is Ike Start, student attorney at the University of Michigan, and I'm requesting to appear on behalf of Ms. Ellison, pursuant to Michigan Court Rule 8.120, under the supervision of Attorney David Santacruz.
Permission to practice is granted.
Thank you.
Yes, this is defendant's motion. But I don't have the plaintiff. So what do you want to do?
So, Your Honor, this case was supposed to be resolved by conditional order of dismissal, which was entered by this court on November 21, 2025. And the relevant terms of that, the conditional order of dismissal was that my client, Ms. Ellison, was to vacate the property by the end of the year and also facilitates funding for Ms. Gannon. And then in return, Ms. Gannon was supposed to return Ms. Ellison's security deposit within 30 days of vacating the premises as required by law. So Ms. Ellison vacated the property. That's my client vacated the property on December 5th, 2025. And that 30-day period for plaintiff to return the security deposit was ended on January 4, 2026. And we had not received the security deposit by that date. So this motion, we have two claims in this motion. First is that plaintiff violated the conditional order of dismissal. And we had not received the security deposit at the time of filing, but since we have received that security deposit after filing, and so the remedy for the breach of the conditional order was simply to get the amount of the security deposit, which we now have. That being said, we have a second claim, which is that plaintiff violated the Security Deposit Act. MCL 5546132 states that the failure of the landlord to return the tenant's security deposit within 30 days of termination of occupancy makes
Did your client supply notice? Or
yes, Your Honor.
A forwarding address?
Yes, Your Honor. She supplied her forwarding address on the day that she moved out via email. And that, I believe that's attached as an exhibit on the motion if you'd like to see that email.
Wouldn't all of the provisions of the Security Deposit Act having been waived if you are placing it in the confines of a conditional order of dismissal?
Here's the judge's big question. Once both sides entered a conditional dismissal order, did they also create a new set of rules? The defense wants the court to enforce the agreement and still award double damages under the statute. But if the agreement changed the process, the judge is asking whether it also changed the remedy. That is the entire fight.
No, Your Honor, the conditional order of dismissal in no way waived the statutory obligations that would make the plaintiff.
Does it say that in the conditional order of dismissal?
Let me take a look. That's also attached as Exhibit A. It certainly gives action to reopen the case and to reinstate the case and for the court to issue a judgment if the terms of this order were not complied with. So I would argue that the conditional order in no way waived. And I would say it's pretty clear from the text that it did not waive the statutory obligations of plaintiff. So continuing on, under MCL 554613, plaintiff is liable to my client, Ms. Ellison, for double the amount of security deposit retained. And And Ms. Ellison,
When was the security
contends-
deposit returned?
it was after the date of the filing, and this was filed on January 29, 2026. So I think it was shortly thereafter. So end of January, maybe early February.
Now the case shifts from paperwork to real-life consequences. The defense argues the delayed deposit wasn't just inconvenient. It put the tenant's next housing at risk and created fear of another eviction fight. That adds emotional weight, but it still doesn't guarantee statutory damages. In court, sympathy helps the story, but the written agreement still has to support the remedy.
But in the meantime, my client was threatened by her new landlord because she didn't have the money to pay for rent. She was relying on the security deposit to be returned, and so this caused great hardship to her, a fallout with her new landlord, and potential more litigation. And she was very anxious about being homeless.
Was there more litigation that ensued?
No, Your Honor.
It was just her worry that she would be sued.
That's correct, and Miss Ellison contends that she relied on the fact that Miss Gannon would comply with the law and return her security deposit. So when she moved to the new address, she told her landlord that, I'll have the money by January at the latest, January 4, and then January turned into February. And the landlord, in my understanding, was days away from initiating litigation, and my client was anxious about being homeless again, her and her son. And this was all because Miss Gannon failed to abide by the law. And so Miss Ellison contends that she is entitled under the statute, and that's the statute. The purpose of the statute is to protect against this exact thing, which is that a tenant would rely on the word of the landlord, but and then the landlord not following through. And I would just say one more thing is that counsel or myself tried to reach out to Miss Gannon many times. When it came to our part, our obligations under the conditional order of dismissal, Miss Gannon was very, very willing to communicate, always answering our calls and emails. But as soon as she got her money and my client moved out of the apartment, it was radio silence from Miss Gannon. I emailed her, I called her, I left her voicemails with nothing in response for over a month. And that caused great hardship to my client. And so my client, Ms. Ellison, requests that this court reopens the case because it was previously closed under the conditional order of dismissal, and then award.
But why wouldn't I consider all of the provisions or the provisions of the Security Deposit Act were, because you'd almost have to reserve that, wouldn't you? Because everything in this conditional order of dismissal circumvents the Security Deposit Act.
This is where the judge zeroes in on a crucial drafting problem. If the parties wanted to preserve statutory double damages, that protection needed to be clearly written into the order. Instead, the agreement appears to change deadlines and obligations without reserving that extra remedy. That's a tough spot, because in litigation, unclear language can erase an otherwise powerful argument.
No, I don't think so, Your Honor. I think
I know you don't think so, but wouldn't you have to reserve it?
Well,
I mean, give me a reason why you wouldn't have to reserve your rights under the Security Deposit Act. You're altering it. You're altering that statute in the confines of this order. For example, it's 4 days and you limited it to 3 days for the time period at which to do that. There's no provision that's laid out. And also you're saying that she's agreeing just to return the security deposit. Just return the security deposit. All of the provisions that would apply within the Security Deposit Act as to what the landlord could do have been altered.
That line from the judge is brutal and revealing. It shows the court believes the defense argument is collapsing under its own logic. Once the order changed how the security deposit had to be handled, repeating "the law is the law" wasn't enough. The attorney needed to explain why the statute's penalty survived those changes, and the judge clearly wasn't buying it.
So, Your Honor, if I may jump in for 1 second here.
No, he's doing just fine losing this by himself. Go ahead.
So I would say that normal practice is, if you've got a COD that could take more than 50 whatever days it is to be paid out on, that you have to explicitly waive the law. But without an explicit waiver, it obtains. So that was our approach.
But you changed what's in the statute. It's usually a 4-day period, right, to receive forwarding address.
Well, we just did it faster, but yeah.
But you've altered the statute.
But
You're
by the 3 days. You've also altered the rights of the landlord to do anything, because even as I read the terms of this, irrespective of whether or not there's damage, irrespective of anything, the security deposit is coming back. That's not the way the statute reads. You've altered the statute, but now you want to enforce the remedy provision that's contained in the statute.
I'm sorry, you're breaking up a little bit, but I don't read the conditional order of dismissal to really do anything other than to benefit the plaintiff. So, I mean, the law is the law, and if we gave more grace.
No, the law is the law, and the law says that if she gives that notice, that if the landlord has damages, the landlord can do something. The landlord, with regard to that security deposit, the landlord with this conditional dismissal can do nothing but return that security deposit. You've altered the statute and the remedies provided to each party under the statute, but now want to enforce the other remedy provision within the statute. I don't think that's how it works. If what you wanted is to say that given everything we've done here, that if you don't return it within 30 days, that she'd be entitled to double the amount, then it should have been said, but it's not said.
Understood, Your Honor. I mean, my client left in a timely manner. I mean, the fact if this might be a different case if my client left the place a mess and and there was
but it wouldn't matter. But it wouldn't matter. That's what I'm getting at. It doesn't matter. She could have destroyed the whole thing, but regardless, under the provisions of this conditional order dismissal, that security deposit had to come back, which is not what the statute envisioned. You can keep shaking your head, but tell me where I'm wrong.
Well, I don't think that this conditional order of dismissal would force her to return the security deposit even if there was damages. I don't think this conditional order dismissal supersedes the law. That's my contention.
Hold on a second, counsel. How do you read that? Look at your paragraph 7. If the defendant vacates the lease premises timely under the terms of this order, plaintiff shall return the defendant's security deposit in the amount of to defendant's checking account or send it via email by forwarding to the address within 30 days of the date that it vacates. Tell me how what you're proposing could even happen.
Well, under the statute, Your Honor, I don't think that the wording that we use in this conditional order supersedes the law written by the legislature. This was just an agreement to get this case settled. I don't.
Yes, you have, because you already altered it with the 3 days versus 4 days. You already altered it, making it mandatory to return it, irrespective of anything else. There's no exception here. There's nothing. there's no exception that if gas, utilities, or anything else is owed, may not have been in this case, but there's no exception in here that if something else is owed, they could take it out of the security deposit. This security deposit was coming back regardless. And the rest of the rights, this court would rule as to what would pertain under that security deposit were not retained or preserved or reserved. And so therefore, your motion to do that, I don't think is equitable and fair under the circumstances, and the court does not believe that that is the intent of the order that I signed. And so therefore, your request for relief is denied.
All right. Thank you, Your Honor.
Thank you.
Final ruling. The tenant got the original security deposit back, but the court denied double damages. The judge found that the dismissal order changed the normal structure of the Security Deposit Act without clearly preserving the tenant's right to the statute's extra penalty. Big lesson. In settlement orders, every word matters. If you found this case shocking, like, share, comment, and subscribe for more courtroom breakdowns.